Next is Mr. V.O. Joshi. है जोशी जी की नहीं? दिख नहीं रहे? मुझे बोलिए ज्वाइन करने के लिए. उसके बाद कौन है? भावेश पटेल. Bhavesh is there. We are taking up the matter of Mr. Bhavesh Patel, 32. My lord. Please, Manoj. Yes, Mr. Patel.
Please, Your Lordship. I am appearing on behalf of Mr. Patel, my lords.
Yes.
My lords, the present application is for regular bail in connection with the offence of 323, 326, 504 to 5062.
What is the allegation of 326?
Yes, my lords. Because of a stick blow, the victim has received a stick blow on her eye, and because of it, it has resulted into the decrease in the visual capacity. A stick blow. Altercation amongst
vision of the victim. Permanent loss of vision to the victim fully bent.
Loss of vision?
Yes.
And any antecedents?
No, my lords.
Antecedents are not there.
Total how many injuries?
On eye.
Only one injury?
Yes, only one eye, and the complainant says that she received fist blows. Fist blows.
Fist blows. And why did you have to go and beat her?
This is an altercation amongst the family members. The complainant happens to be, the victim happens to be the aunt of the accused. This is there is a rivalry in the family, and the complainant says because of there was some dispute regarding the water pump.
Heard Shri
Rajesh Vyas.
Bhavesh Patel, learned counsel for. You are Mr.
Rajesh Vyas.
Adesh Vyas.
Yes, Rajesh Vyas.
AADESH.
RADHES. Rajesh.
Rajesh. Achha. RADS. Rajesh Vyas, advocate for Mr. Bhavesh Patel, learned counsel for the applicant. And Shri Mandan Mehta, learned APP for the state. Learned counsel for the applicant submits that the applicant is in jail since 4th December 2020. It is further submitted that the applicant has no criminal antecedents. It is next submitted that it was an altercation between family members over a water pump dispute. There was no intention to cause any injury in the eye. However, it was by accident that the injury has been caused. Apart from the said injury, there are no other visual injuries. Bail granted.
Yes, my lords. May I leave, my lords?
Yes. Okay. Hey, Mr. Joshi is not come. Huh? आए जब आएंगे तब देखेंगे. अभी आगे चलते उनको बोल दीजिए कि ज्वाइन कर लें. Now, serial number 33, Mr. Manan Mehta has already done this matter. 34, who is doing?
What Mr. Devnani?
I'm doing 34. I'm.
Then 35, 36?
Manan.
Achha. Then 37, 38, Devnani?
My lords.
Right. There is no Mr. Joshi, right? So we go on to the next case. It's a Chakawala. Chakawala is there. Shin Chakawala.
Is complainant, original complainant.
Who is complained?
Rajesh Kumar. Consent letter with counsel.
Mr. Anshin Desai.
Please.
And
Mr. B. N. Zumba.
BL Limbachia. They are appearing for complaint. Yes, Mr. Chakawala.
Ji sir, as such, nothing remains in this application, sir. I was granted anticipatory bail by order dated 19/8/2020. Then after I was instructed to remain before the investigation officer on 29/9/2020, and one condition was laid down while granting my anticipatory bail, and that was that I had to prefer a regular bail application within a time period of 15 days. But somehow, because one of my relative expired, I filed it after a delay of 1 or 2 days, sir. And that my regular bail application was rejected on solely on the count that there is a delay of 1 day. This is a very limited scope wherein this application has been preferred, sir, for regular bail. May I point out the condition, sir, that was imposed or the direction that was given by the Honorable Court, sir? It is
That is an order dated
19/8/2020, sir. Page number 16. On merits, I'm already granted anticipatory bail, sir. Condition number 10.2, page number 16.
Yes.
Right, sir. In the event of the arrest of the applicant, he shall be released on bail subject to aforesaid conditions, and this order shall remain in force for a period of 15 days from the date of his arrest to enable the applicant to file application for regular bail in accordance with law. And now there was a delay of 1 day, sir. I was supposed to file an application before 15/10/2020, but since there was a death in the family and I was myself quarantined, I filed the application on 16/10/2020 before the district court, sir.
And where is that order?
Order rejecting is at Annexure A, page number 7. Page number, sir. Page number 20.
Annexure C.
Annexure C, sir. Yes.
So it has been rejected only on the ground that it has been filed beyond period of 15 days from the date of arrest.
Yes, sir.
Yes, Mr. Desai, what do you say?
No, that's not correct, Milos. He's not pointing out. This is an application under 439. He is not in custody. The court has said that he is not in custody. How do I exercise 439 powers? He is not in custody at all. The coordinate bench has relied upon 2 Supreme Court judgments. Milos, I have shared it with the learned chest that on this point, in criminal misdemeanor application 13701 of 17, and even the concept of deemed custody or custody before court is refused. In a judgment confirmed in Supreme Court on a similar case, Milos, where Supreme Court had granted time and he was in delay, the court said that you have to go for exercise of powers under 439, because 439 says in custody. So therefore, whatever may be the facts, 1 day or 2 days, and like in that case which I am referring to, Milos, before my lords, which is confirmed till Supreme Court, judgment of late Honorable Justice Udwani, Milos, dated 30th of August 2017, where this is dealt with in detail. And the court has said that 439 powers can't be exercised. You go in custody, then you can apply. Your today is not in custody. Kindly see. The condition which was granted, he may be delayed because on facts also he is incorrect as far as this corona thing, because corona has helped many people like him. So it is to his advantage they are working. But whatever, that is on facts. As far as this case is concerned, if my lords can have 13701 of 17, the judgment which I have shared, Milos, my learned friend has shared, if my lords have it.
What I was trying to understand was that there is a very detailed order passed on 19th August 2020.
That's right.
While disposing of his anticipatory bail application.
That's right.
Correct?
Right.
That order is also passed after hearing learned counsel for the parties.
Lordships.
Correct?
Lordships.
Now, he has read out paragraph 10.2 of that order.
That's right.
Now, let us understand what this 10.2 condition means.
Lordships. I'll just read it slowly.
Yes.
In the event of the arrest of the applicant, he shall be released on bail subject to aforesaid conditions.
So where would be the question of his arrest when there was an anticipatory bail order?
Let me finish this one. And this order shall remain in force for a period of 15 days from the date of his arrest to enable the applicant to file application for regular bail in accordance with law. Now he is shown as arrested in this case on 29/9/20. These are the facts, 29/9/20. So on 14, yet to prefer an application on or 439 application on or before 14/10/20. Now, my lords, application will be under 439, so he preferred under 439. The order which my learned friend, it's in Gujrat, I can just run through and translate for my lords. It's a short order. On page 20, if my lords have, the relevant portion is on page 20, 23 and 24. My lords, the court has said that to exercise powers under the code, my lords, of 439, he has to be in custody. Right? Only this is there. Now he is not in custody. He is not even before court. So the court says there is no.
He has not surrendered.
No, that's what I'm saying. He is today outside. He is not in custody. How can
How the regular bail can be entertained?
That's what. That is the point, Milos. That can't be entertained. That's what the point. That's the only point.
Chakawala,
Sir, I was supposed to surrender before the investigation officer. He has granted me bail. I have furnished my bail before him. Certainly, I have surrendered on 29/9/2020 before the police officer. And after furnishing and after providing a bail bond of ₹1 lakh, I was released under the protective umbrella of anticipatory bail, sir.
so you have been released on personal bond.
On personal bond as well as a bail bond, my lord. A bail surety, I had provided my brother executed a bail bond. And
Before the IO.
Yes, sir. Before the IO.
When did you surrender?
On 29/9/2020, sir.
And the same day you were released.
Yes, on the same day I was released, keeping in mind the anticipatory bail order, sir.
All right. Now, when did you apply for?
I applied on 16/10/2020 for regular bail, sir. I'm sorry, sir.
I'm sorry to intervene. That is arrest, not bail.
Sorry, sir, I'm not able to hear, sir.
On 16/10/20, you applied before the lower court for under 439.
Under 439, yes, sir.
Now, that application has been rejected on which date?
It has been rejected on 7/11/2020.
On what ground?
On the sole, my lords, it is referred at internal page 4, which is at page number 23. The
Yes.
only aspect there was that it can only be considered to be a deemed custody if it was within a period of 15 days. But since you have approached after 1 day or 2 days, therefore I am rejecting. That is the
One more thing, my friend.
Now,
made
just
it
1 minute.
friendly.
You are still outside or you are in jail?
I am outside, sir.
How can you remain outside beyond 15 days from the date of arrest?
I'm sorry, sir. My lords,
After the court provided in the order or as per paragraph 10(2) that in the event of arrest of the applicant, he shall be released on bail subject to aforesaid condition. So you were released on bail subject to aforesaid condition. And this order shall remain in force for a period of 15 days
right, sir.
from the date of his arrest.
Right, sir.
Enable the applicant to file application for regular bail in accordance with law. Now, if you would have filed a regular bail application within 15 days from the date of your arrest and being released on personal bond, as per this condition, then your regular bail application would have been considered, treating you to be still in custody. That period of custody expired on 15 days.
Right, sir. Right, sir. So just one aspect, sir.
So therefore, you have to surrender, go to jail, and then apply for bail.
That's right, man. That's the only point.
My lords, in that case, but I am already released. I am already protected on
Mr.
marriage.
Shakawala, that protection was for 15 days.
I understand, sir, but
You count 15 days from 29th and you tell me what is the date
sir, the
for which
reason
that order would expire.
I agree to this that there was a delay of 1 day and it was on the count that my relative expired and I was in touch with him and there was this pandemic situation that was going on. Kindly
These
consider.
orders don't take into consideration all these aspects, whether somebody is died or not.
I understand.
Only so long as you are alive, you have to surrender.
My lords,
You should have applied for bail. Why were you waiting for the last day? Why did you not apply for regular bail on the second day?
it was
The court did not say that you wait for 15 days. On the 15th day, you apply for bail.
I agree,
No.
sir, because it was that to
So
enable
if
the
you try to act smart, then you suffer. Look here. You are withdrawing this to go and surrender and apply for regular bail.
My lords, I'll
You
have
want a liberty from this court.
I'll have to seek. My lords, in that case, can I again approach the learned district court
Yes, after surrendering.
after
Yes.
surrender? I shall
Oh, yes.
remain.
Your
I said-
right of 439 is not taken away. You have to apply for bail, regular bail, and get it. The only benefit extended was that for 15 days you could have remained out and applied for regular bail on that personal bond,
My lords,
which you exhausted and you did not.
now the ambiguity on my part, there is one ambiguity, sir. Now this offense has been the power are been given under 439. So I'll have to surrender before the learned JMFC court, learned IO.
I am not going to advise you on this. That is your problem.
My lord,
You understand what to do. You are the lawyer. I am not the lawyer.
I understand, sir, but that is I am a 58-year-old person, my lords.
58 years or 98 years old. You have to follow the law.
I understand, but what will happen is that I'll have to surrender before the IO or the learned JMFC court. Now
I
that
don't know.
now that court would not have powers, my lords. And furthermore, I have given it on affidavit before the learned district court that kindly consider it that as if I am in your deemed custody, sir, before the learned district court, and I was even ready to be available before the learned district court. I have no objection to that. I am not running away from the law, sir.
Contacts district court criminal lawyer and he will advise you what to do and how to get out the same day. You need to, if you don't know, then you find out. Ask Mr. Desai, he will tell you.
After my lords pass an order, I'll tell my time.
लिखिए आप इसको विड्रॉ कर लीजिए
हाँ सर, I'll withdraw with the liberty that I might get out on the same day, sir. On a lighter note.
लिखिए भाई heard Shri Kishan. Who is appearing for the state in this case?
I am appearing 34.
Mr. Dharmesh Devnani, learned APP for the state. Commerce Shri Anshin Desai, learned senior advocate, assisted by Shri B. N. Limbachia, learned counsel for the complainant. Full stop. After arguing to some length, Mr. Chakawala stated that this application may be dismissed as withdrawn, leaving it open to the applicant to avail such other remedies as may be available in accordance with law after taking necessary steps as may be required under law. Accordingly, this application is rejected with liberty as played.
May I request for one thing, sir?
What?
Sir, at least some protection may be granted up till then, sir.
Don't make this mistake again. I am not going to commit that mistake.
What I am requesting is, on merits, I have also filed a quashing petition wherein rule has been issued.
Very well.
Excellent case on merits, but just because
you want to stay away, you can stay away.
My lords, that is not the
as
case.
long as you can and pursue your. But if the police arrests you, then you will be in great difficulty.
Well, he's complicating things for himself in the quashing by a speaking order. Interim relief is refused. I have appeared. I got the copy of the order.
Very well. That is for them to decide. Next case.
What I am requesting is just for a week's time I be granted because vacation is coming up and it would be really difficult, sir, to work.
There are no vacations in the district courts.
I understand, sir, but still it would be really difficult.
Mr. Chakawala, no.
Obliged.
Obliged to Lordship.
Deeply obliged.
Deeply obliged. We may live with your Lordship's permission.
Yes. Mr. Vishwanath Joshi आ गए. हाँ. ये मेरा टाइम खाते जा रहे हैं. 31. Now we have this serial number 31.
My lord.
Please, my lord.
Yes.
This is a regular bill before charge sheet, my lord. Offense under NDPS Act, my lord. 287 cup syrup was recovered, my lord.
How many antecedents?
Not a single. There's maybe a prohibition, my lord. Maybe of the prohibition, my lord.
One of prohibition.
Only one of prohibition.
Yes, but my lord, here the cup syrups having my lord codeine. 287 bottles, 100 ml each.
287 bottle was recovered, my lord, from the vehicle.
He must be taking it to some pharmaceutical shop पे लेके जा रहे होंगे बेचने के लिए और आपने पकड़ लिया रास्ते में उनको.
No.
और कोई चरस गांजा तो नहीं है ना?
No. Cup syrup my lord, having codeine.
लिखिए भाई. Heard Shri V.O. Joshi, Learned Counsel for the applicant, Shri Mandan Mehta, Learned APP for the state. Learned Counsel for the applicant submits that the applicant is in jail since 8/11/2020. It is next submitted that the only previous antecedent of the applicant is of a prohibition case. It is next submitted that the recovery made are of cough syrups. Bail granted.
Please, highly obliged, my lord. May I leave, madam?
Yes. Next one is Mr. Darshan Dave.
Complaint.
क्या नाम बताया? टाउन वाला ये जबो वाला हाँ?
I forwarded one order of the Honorable Division Bench in habeas corpus petition in the morning. If my lords have got the same, my lord. This would be relevant for this petition. My lord.
अच्छा
Lordships, I am appearing for the original complaint of victim. I have also sent some documents for the consideration of this case, if it is needed.
What have you said?
I have sent the order.
So Zabo वाला ने कुछ order भेजे?
Order would be the same, my lord.
Order would be the same, FIR and some messages.
Along with that, yes, they are there.
Yes.
ठीक. हाँ बताइए. Yes, Mr. Dave.
Please, your lordship. My lord, complainant is also a government servant and present applicant is also a government servant, my lord. Here, my lord, they both are married. They both have love affairs since 2016, my lord. In complaint itself, she says that they have love affairs from 2016. And they got married on 9/9/2018 at Ahmedabad, my lord.
अच्छा, आप गए थे?
No, my lord.
अच्छा, कोई बात नहीं. Then, what is this FIR about?
FIR is under section 376, my lord, and there is a point of delay is also considered, my lord. There is a incident of 5 August 2020 and FIR is lodged on 13 August 2020, my lord.
Then what is this?
Habeas corpus?
Who filed the habeas corpus?
My lord, mother of the complainant has filed a habeas corpus petition before this honorable court, my lord.
Saying that you have illegally detained her.
No, my lord, as far as she is my wife, my lord. She
and
is
what
my
does
wife.
she say? But she says it's not your wife.
No, my lord. And on 9/9/2018, she has already married with me, my lord.
And what is the proof of marriage?
My lord, there is a marriage registration certificate is also having, but after filing of this application, I have received from my counterpart, my lord. And even though complainant itself says, my lord, on page 20 also, my lord. Sorry, my lord. Page 19, my lord. Page 19.
Yes.
In middle portion, ત્યારબાદ મારી સાથે 9/9/18 ના રોજ અમદાવાદ અસારવા કોર્ટ ખાતે મેરેજ કરી લીધેલા. અને ત્યારબાદ વડોદરા વાઘોડિયા રોડ ખાતે ભાડાના મકાનમાં અમે સાથે રહેતા હતા.
Acha, all right. Now, what are these orders passed in the habeas corpus petition?
My lord, may kindly have a look at, my lord, the order dated 26th August 2020 of Division Bench.
Yes.
My lord, second paragraph, my lord, may kindly have a look at.
Yes.
She was, my lord, corpus, that is complainant, was produced before the learned court below. And, my lord, via video conferencing in a blackout room, she had interacted with the Honorable Division Bench. She had, in uncategorical terms, my lord, she had conveyed that the present petitioner, being a, my lord, holding a post of PSI in traffic branch, has taken certain disadvantage.
She admits of having married the applicant?
No.
Yes. It is there on the next page itself.
Page 19.
According to her, they got married at some point of time. Thereafter, on realizing that the relationship could not continue, the official divorce took place.
Lordships, yes, I'm sorry. Yes,
Marriage is admitted.
She is admitting, my lord, that aspect.
Now she is back with her parents.
Now she is back with her parents, and, my lord, only one thing if it appeals. Paragraph 3 and paragraph 4 of that order of my lord's Division Bench. As per the order of this honorable court, the FIR is lodged.
All right, FIR is lodged, that may be investigated, but why keep him in jail?
Lordship.
Yes, Mr. Zabwawala, what do you have to say?
this is not that case, Lordship, that the marriage was done. Then after, Lordship, the officially divorce took place. And this incident, Lordship, has been occurred after the divorce has been took place when she was residing with her parents. She was illegally kidnapped and taken to some unknown place, Lordship, where she was kept when she was kept in confined, Lordship. Now, then after the registration of this FIR, this is what the case in the habeas corpus. But when the habeas corpus, Lordship, paragraph number 2, if my lords may kindly see that official divorce took place, which was observed, and then after this lady does not want to continue any relation. Therefore, Lordship, she was residing with the parents, and then after from the house of the parents, Lordship, she was taken place. This was a very clear observation. So it is not the case that she was married. The official divorce took place. She don't want to continue with the relation, even though he has taken her in illegal manner, Lordship, and kept in the custody, in confinement, Lordship. This is a very clear observation. And after registration of the FIR, Lordship, this is not the case. After registration of FIR from the jail, Lordship, he is a very highly influential person. Page number 7, Lordship, with my compilation. She is continuously giving threat, Lordship, that you withdraw this complaint. Page number 7 is the other FIR, Lordship, which was recently registered against this person. At page number 7, the FIR dated 11 December 2020. The entire narration in the jail, Lordship, he is using phone, continuously is giving messages, continuously is giving threat by using his position. My lords, may kindly see page number 8, the FIR. So this is not a simple case, Lordship, that he is just married, and it is not the fact, Lordships. The girl, the lady, Lordships, was ended up the relation. She has very clearly said that I don't want to keep any relation with you.
What is the date of abduction?
Date of the abduction, please, Lordship. I am not having the that first FIR, but if my lords may kindly see.
Most probably in the first week of mid-August.
First week of August, then after the mother has made an application before the Dahod police station. Dahod police station did not register FIR. Therefore, the habeas corpus petition. Because
it is dated 5th of August 2020, mentioned at page number 14 of the FIR. 5th of August 2020.
And then she was released on 26th August.
Yes, 26 order by order of this
before the division bench. So yes. I would only submit that this division bench observations are more than 164 statement, because in a breakout room, my lord, various details have been shared by the corpus before the honorable division bench.
Even the learned trial judge has also observed that he is influencing person and threatening the the complainant and his family. The manner, Lordship, the messages he has done. Page number 12, the message.
My lord, I am in jail since 6th November 2020, my lord. There are any other FIR file against me, my lord? It is even though my petition paragraph 13, my lord, he has given a possession to his parent on 5/8/2020, and parents have filed a habeas corpus petition on 6/8/2020, my lord, after taking the possession of the girl, my lord.
No. From where was the girl recovered? Who produced her in court?
Police authorities, my lord.
Mother.
Police authorities from the custody of the husband or the applicant or her parents?
Her parents, my lord. Later on from her parents, but my lord, the present petitioner being accused, he was constantly harassing the my lord corpus. That is what the case.
My lord, now I am suspended, my lord. I am suspended from police, my lord. I am since jail.
You are completely finished. You are suspended. You will lose your job also. And you will remain in jail also, and you will be convicted also for what you have done. Abhi, you continue to stay inside for some more time.
My lord, if your lordship not convinced me, I have liberty to file after charge sheet, my lord.
Either you want that, I can permit you to do that, or I can direct this matter to come up in February.
Oblige, my lord. In February, my lord.
लिखिए भाई, heard Shri Darshan Dave, learned counsel for the applicant, Shri Mannan Mehta, learned APP for the state, and Shri A. Zabuawala, learned counsel appearing for the complainant. Let this matter be listed again on 17th February 2021 before the appropriate court. It shall not be treated as tied up to this bench.
I may be permitted to file my wakalatnama for the original complaint.
You may do whatever you like in the meantime.
Please, Lord. I'm deeply obliged.
Oblige, my lord.
With my lord's kind permission,
I am obliged.
Yes.
May I leave, my lord?
हाँ बिल्कुल, अंकित बच्चानी.
Oblige.
Saurabh Chande.
Please, Your Lord.
Yes, Mr. Bachani.
Your Lord. 06, 506 and 114, Your Lord. Present applicant number 1 is the father of applicant number 2. Complainant's daughter had married with the present applicant. Complainant's son had been married with the present applicant daughter before 4 years ago. Your Lord. During their marriage span, they having one daughter. But anyhow, their marriage life was not going to good. So for settlement, the complainants or present applicants has called to some of the near Sarpanch.
Your son-in-law has committed suicide.
No, yes, my son-in-law has committed suicide before 2 months ago.
लिखिए भाई. Heard learned counsel for the applicant and Shri Mannan Mehta, learned APP for the state. The applicants are in jail since 4th of December 2020. Comment is submitted by learned counsel for the applicant that they have no criminal antecedents. It is next submitted that there are no ingredients of Section 306 IPC of in any manner abetting the suicide committed by the son of the complainant. The applicants have been falsely implicated. Granted.
Oblige, Your Lord. I may be permitted to leave, Your Lord.
Yes. Please lead the way. Yes, Mr. Dave.
Please, this is after charging. The alleged offences are under Section 377 and 511 and Section 8, 12 and 18 of the POCSO Act. Now, before I go to the marriage law, though the complaint is under Section 377, the charge sheet has been filed under Section 376. And there it has been stated that it was an attempt only in the charge sheet.
No, the allegation is that you sexually exploited the son of the complainant.
Yeah, that is what, but the charge sheet is under Section 376.
376?
Yes, sir. So, surprisingly, how the charge sheet is filed under 376?
Must be some mistake.
No, the learned judge has also discussed that how the charge sheet is filed under Section 376.
376 against men do that?
It is only against the woman, not against him.
That is what I generally understand. Let me read IPC again.
Yes, I have read 376.
Not against me? Mr. Devnani?
I am also only read.
And charge sheet 376 में गलती से आ गई होगी.
But there are a lot of things the honorable, it is though in vernacular, but there are a lot of things the honorable court has observed against the investigating officer, Manoj.
Yes.
In fact, there are 3 paragraphs where it discusses that how in what direction the investigation was required to be done, and in an utmost, though he is my officer, but the court below has considered that the investigation is absolutely hopeless, sir. That is what he has observed.
Even the Android phone is not recovered, my lord, which is alleged to have been thrown to the boy, my lord. And there is no medical evidence, my lord. The only thing against me is my lord, the statement under section 164.
Why have you been falsely implicated?
Because of the business rivalry, my lord, there is a shop opposite to my shop of the elder uncle of the victim boy. Otherwise, my lord, the complaint is given after 1 month. If your lordship sees the complaint, what the complainant says, my lord, that on 4/9/2020, the complaint is filed, wherein he says that before 1 month, my son has said that I have some pain on the backside private part, my lord. Therefore, an on-paid was, my lord,
चलिए लिखिए. Third, Mr. B.C. Dave, learned counsel for the applicant, and Shri Dharmesh Devani, learned DPP for the state. Learned counsel for the applicant submitted that in the statement that the applicant is in jail since 7/9/2020, that the applicant has no criminal antecedents. Further, that it is a case of section attempt only, as stated by the victim in a statement under section 164 CRPC. Further submitted that the applicant has been falsely implicated on account of business rivalry. Granted.
please, oblige, sir. May I leave, sir?
Yes.
May I leave, sir? Please, sir.
Anand Jiva.
Please, Your Lordship. My Lord, I appear, my Lord, for Anand Jiwal.
Yes.
Here, my Lord, the offence, this is regular bail application. My Lord, the offence is under section 498A, 306, 114 of IPC, my Lord. The petitioner is mother-in-law. My Lord, the general allegation against husband, sister-in-law, and my Lord, the present petitioner, my Lord. Regarding causing harassment, and my Lord, as she was not liked by them, my Lord. That is the allegation. And there is no specific demand of dowry. However, my Lord, there is allegation that they were also causing, my Lord, torture by as she has not she did not bring, my Lord, the enough dowry. That is the only allegation. And my Lord, the sister-in-law has been enlarged on, my Lord, anticipatory bail.
Okay.
Please.
Third learned counsel for third Shri PM Dave.
Please.
Advocate for Shri Vishal Anandjiwala, learned counsel for the applicant, and Shri Dharmesh Devani, learned DPP for the state. Their counsel for the applicant submitted that the applicant is in jail since 9/12/2020. She is the mother-in-law?
Yes,
my lord.
The applicant has no criminal antecedents. That she is the mother-in-law of the deceased. Further submitted that the applicant had no role to play in any kind of abetment as alleged. Further submitted that other co-accused, sister-in-law of the deceased, has been granted anticipatory bail. Granted.
Obliged. Deeply obliged.
I am leaving I'm leaving the meeting. Please.
मिस्टर नायर के साथ कौन है? एनआर मेहता। ये एनआर मेहता ये यस
sheet, and the applicant is of about 64 years. The FIR was registered on 25th September 2020 under the offences of 406, 420, 409, 120B, 50.
What is the allegation against you?
Pursuant to the lodging of the, there is no direct allegation against me. I am just the father-in-law of the accused number 1. And according to the informant himself, he has mentioned in the FIR that when the accused number 1 took the informant to his shop, he introduced me saying that I am the father-in-law and that when I am traveling for business work, my father-in-law manages came for
Mr. Mehta, what is this?
Money.
I can't hear Mr.
I understand. 7 crore and 89 lakhs goods have been purchased by accused number 1 and 2.
Right.
Those amount has not been repaid. In presence
there
of
is a process for recovery of your amount.
I understand, Milord. In presence of accused number 3 and petitioner is accused number 4. The amount, some of the transactions were done, Milord. Therefore, he was present, and similar, Milord, kind of modus operandi. He is, Milord, facing the one prosecution of 2020, same allegations.
There is one antecedent.
There is one antecedent of similar in nature, Milord. And the main accused is it is not traceable. That is his, Milord, son-in-law.
He is not traceable.
He is not traceable. He is perhaps in Nepal.
And he is the father-in-law.
Present petitioner is father-in-law of accused number 1.
His presence has been shown at the place.
Yes, and in his presence, some of the transactions were done, but total amount involved is, Milord, 7 crore and 89 lakhs.
But the main transaction is between the one who has not been arrested.
Lordships.
लिखिए.
There is no privity of contract between me and the informant.
अभी और ज्ञान बताना है आपको कुछ?
नहीं सर, I'm grateful.
जब हम ऑर्डर लिखने लगे तो आप ज्ञान बता. Heard Shri N.R. Mehta and counsel for the applicant and Shri Mandan Mehta and APP for the state. Full stop. And counsel for the applicant submitted that the applicant is in jail since 27/11/2020. It is further submitted that the applicant has been falsely implicated only because he is father-in-law of the alleged main accused, who is said to have entered into commercial transactions with the complainant. The only role of the applicant, as stated in the FIR, is of being present at the time of transaction. So lastly submitted that the applicant has no direct contract, is not in direct contract with the complainant. Granted.
Great. With my Lord's permission, I will.
Yes.
Grateful.
शुक्रिया बोल रहा है तो उसको टाइम चाहिए 8 दिन में.
किसको?
तेजस पारो.
डेट चाहिए 40 नंबर में. कौन सी डेट? 8th. Very good. Mr. Mehta, in serial number 40, Learned Counsel wants time and adjournment for 8th January.
No objection, Milord. It may be adjourned.
on the request made on behalf of Shri Tejas Barot, Learned Counsel for the applicant, list on 8th January 2021. Shri Mandan Mehta, Learned Counsel, Learned APP is present for the state. हाँ, before the appropriate code कर दीजिएगा, याद कर. Now, what are these? Serial number 41. We will finish this board and then break for lunch.
Yes, sir.
We have 3 matters left. Yes, what is this?
Please, my lord. So, as per my lord order, my lord, I have filed the affidavit, my lord. Stating that, my lord, I have, my lord, sent rupees, my lord, 2 lakhs by way of NEFT, my lord. I have annexed the statements, my lord, page 34, my lord. On 1st August, my lord, rupees 49,000 on account of, my lord, husband of the complainant, Mr. Sushil Dubey.
This was kept only because if your lordship recollect, this was kept only today for the purpose of verification whether 2 lakhs he says is paid by RTGS, 9 lakhs he said is paid by cash. Right. For that purpose, it was kept, my lords.
Yes.
That is the material he is placed for verification.
I wanted to see that proof whether he has actually written it or not.
No, since I don't have a copy, my lords, I am only reminding your lordships that this for this purpose,
yes.
My lords.
Grateful.
My order records that. To show documents how the amount credited in the account of the applicant was returned to the complainant by RTGS board.
Please.
लिख लीजिए. Heard Shri Vishal Mehta, Learned Counsel for the applicant, and Shri Dharmesh Devani, Learned APP for the state. Full stop. On 22/12/2020, the following order was passed. Quote कर दीजिएगा. ठीक है? Full stop. Today, an affidavit has been filed by the applicant giving details about the transactions and the amount being credited in the account of the complainant. A bank statement is also annexed. Okay. Learned Counsel for the applicant submitted that the amount having been substantially returned, the FIR has been lodged only to claim interest from the applicant. Okay.
That is after a period of 9 years.
And that too after a delay of 9 years.
Please, sir.
Granted, anticipatory bill.
Please, grateful. I'm on that. I may take leave.
Yes.
Please.
Now we have Mr. Mayank Chawla.
But this is a case of eyewitness, but my friend had pointed out that there were 2 cross complaints. 312 is the offense which is registered for which he is seeking bail. The case of the prosecution is that there is an eyewitness and he has given a blow on the head of the body of the deceased. But my friend pointed out that there are 2 subsequent complaints against each other and there was stone pelting for which your lordships had adjourned it today. My friend had to place on record those 2 complaints.
My lords, I have supplied the copy to my learned friend Mr. Dharmesh Devani, as well as my lords, I have supplied the copy through WhatsApp to Mr. Pratik Bhai.
We got it. Yes.
Yes.
Mr. Devani, have you seen?
There are 2 complaints. One is a subsequent complaint from this side and again a complaint 314 from the side of the present accused.
With regard to the same transaction, same incident?
Yes, my lord.
In continuation. It is in continuation, sir.
It is in continuation.
There are 12 issues in the both sides.
लिखिए भाई. Pursuant to order dated 22/12/2020, Shri Mayank Chawla has placed on record the copies of the FIRs number 313 and 314. ठीक है, उस order में लिखे number ले लेना अपने. Copy of the same has been provided to Shri Dharmesh to the learned APP. ठीक. Next paragraph. heard Shri Chawla and Shri Devnani. Next, counsel for the applicant submitted that the applicant is in jail since 16th of May 2020.
Minors.
It is further submitted that the applicant has no criminal antecedents.
Minors, one antecedent of 2016 and another of the same date.
Achha.
Which is of same.
Criminal antecedents mat likhiye. It is next submitted that in fact it was a free fight between the parties and cross FIRs were registered in which injuries were caused on both sides. No, both sides, huh? Full stop. It also submitted that the injury said to have been caused on the head is by
Further, there is no blood stains, my lord. That may also.
Bail granted.
Okay. Obliged, my lords. May I leave, my lords?
Yes.
We are also thankful that the all is streaming through YouTube, and we are also being seen by many of our colleagues.
Yes.
We are thankful, my lords.
Very well.
Obliged, my lords. May I leave, my lords?
Yes.
Okay.
My lords.
Yes, what is this?
Yes, Mr. Chaudhary, Vikram Chaudhary is a senior counsel, is appearing with me, lordship. May I accept him?
Yes, Mr. Chaudhary.
May it please your lordships. My lords, I have been in custody now, my lord. Initially, my lord, I was arrested in this case, where, my lord, there was no evidence on the statement of a co-accused.
Mr. Chaudhary,
my lord,
we are running short of time. Today is the last day.
All right, my
and
lord.
it's already lunch recess on. 2:30, I have a division bench to assemble.
Please, your lordship.
So I will fix a date, whatever you want, in the opening.
My lords,
and this matter is going to take some time.
Can consider granting me a short-term bail. I have been granted bail by the other. All right. Opening day, my lord, convenient.
Opening day, yes.
Please, your lord.
You can argue at leisure then.
All right, my lord. Deeply obliged, my lord. I know it's and my lord, there was an article in New York Times. The judges pass much better orders when they've had snacks. So, my lord, we'll have it on that day. My lord.
Yes.
Please, your lordships.
Right. You heard Shri Vikram Chaudhary along with Shri Chetan Pandya. Mr. Vikram Chaudhary is a senior counsel?
That's right.
From Delhi, Bombay?
My lord, I'm in Delhi.
Delhi.
Delhi and Chandigarh.
Senior advocate, assisted by Shri Chetan Pandya, lead counsel for the applicants. And Shri Mitesh Amin, learned public prosecutor for the state. Due to paucity of time, the matter cannot be heard today. Let it be listed on the reopening day after winter vacations, that is 4th January 2021, before the appropriate court. Matter shall not be treated as tied up to this bench. Thank you, everyone.
My lords.
Grateful.